Hey there, estate planning attorney Paul Rabalais, and in this video, I'm going to go over 6 different powers that a trustee of a trust has. Oftentimes people come in the office, they're like, or they call, whatever, they say, Paul, I'm involved in a trust, and the trustee of the trust just did blank. Does that trustee have the power to do that? So that's what we're going to talk about, 6 different powers that a trustee has in another video that I'll link to, I think, there. I talked, and I made it recently, I talked about the various, I think it was 5 different duties of a trustee, but in this video we're going to talk about powers. Now I'll start out by saying the nature and extent of the powers of a trustee are initially determined from the trust instrument provisions. So if you're wondering whether a trustee has a power to do something, the first place you look is the trust instrument. And many trust instruments have whole sections of trustee powers. However, some trusts say that the trustee will have the powers that are described under trust law. And so when a particular power that you're questioning isn't provided for in the trust instrument, you have to look at the underlying trust law. So I live and work in our great state of Louisiana, and so as I talk about these various trustee powers that our Louisiana trust code provides, just understand that your state may have different rules on the various trustee powers. Okay, so here we go, 6 different powers. I'll also explain when I get to certain powers where people like to deviate from what our trust law provides. I'll talk about that as well. First one is the trustee has the power to incur expenses. That's kind of typical, but it really only the expenses that are necessary to carry out the purposes of the trust. Sometimes trustees need to pay for investment advice, legal advice, tax preparation. Sometimes trustees have to pay for maintenance expenses regarding trust assets that they are the trustee over. So it is not uncommon for trustees to have to incur expenses to fulfill their role as the trustee. Number 2, leases. So a trustee may execute a lease of trust property as long as the terms are reasonable. And here's a little caveat, even it's okay for a trustee to execute a lease of trust property, even if the lease extends beyond the term of the trust. So just be aware of that. All right, number 3, here's where we're getting into some stuff we see a lot. Sales. The trustee may sell trust property unless it's forbidden in the trust instrument, or if it appears from the trust instrument that the property is to be retained in kind. Now, there are some prohibitions on the person who creating the trust providing that trust assets will never be, can never be sold. For example, the settlor, which is the person who creates the trust, can't forbid a sale of what's called immovable property, really real estate. The person who sets up a trust can't forbid a sale of immovable property for a period of 15 years from his death. So let's go back and let me give you an example before I get on to number 4 of, there's so many different kinds of trusts, and really these rules I would say don't apply to the avoid probate revocable trust, because the settlor is the trustee and the settlor can at any time revoke the trust, put everything back in his name. So we're talking really referring to irrevocable trusts, and there's many different kinds of that. I'd say maybe the most common form of irrevocable trust is when, let's say, a husband dies and he doesn't want to leave his entire estate outright to his wife because he's thinking he doesn't want his wife to then get remarried and leave his estate to her second husband. So what he does, he wants to provide for his wife, but also he wants to protect his children. So he says he leaves his estate to a trust for the benefit of his wife for the rest of her lifetime. And then when she subsequently dies, all of those trust assets revert back to his children. And his wife may or may not be the mother of his children, but the husband is comfortable arranging for leaving his estate to a trust because he has two goals. One, he does want to provide for his wife, but two, he also wants to protect his children so that they kind of automatically get it when that surviving wife passes away and she can't leave it to other people. So that's a common trust. It's irrevocable after the husband dies. So all of these trust powers rules apply. And now who's going to be the trustee of that trust? It can be any one of a number of people. Maybe the surviving wife is the trustee of the trust. Maybe one or more of the children are the trustee of that trust. Maybe the surviving wife and one of the children are co-trustees of that trust. Maybe some other individual is the trustee of that trust. Maybe a corporate trustee is the trustee of that trust. So it could be any multitude of options regarding who the trustee is, and all these trustee powers rules apply to that trustee. So going back to our power number 3, where a trustee has the ability to sell trust assets. However, the settlor, the husband in our example, cannot say, after I die, this piece of land, the trustee can never sell it. It can only he can only prohibit the sale for 15 years after his death. Okay, trustee power number 4. In our environment of lawyers are everywhere and everybody sues everybody for everything, trustee power number 4 enables the trustee, or gives that trustee the power to compromise, submit to arbitration, or abandon claims affecting trust property. Makes sense. We're a very litigious society. Trustee power number 5 is the kind of a common sense one, the powers with respect to stock. So a trustee can exercise all of the powers that holders of shares of stock or other securities can have, including the right to vote those shares either in person or by proxy. All right, and then trust power number 6 involves, and there's several parts to this number 6, the powers of multiple trustees. Now here's one where we often see the settlors of trusts saying, you know what, I realize that's the law that would apply if I don't specifically designate something different, but I want to specifically designate something different and deviate from what our trust code says trustees' powers would be in the event there are multiple co-trustees. So let's take a look at that. First, if there are 2 co-trustees, our trust code says the powers that shall be exercised by both of them unless otherwise provided by trust instrument. So sometimes maybe a parent says, I'm leaving my estate to a trust, or maybe a parent is setting up a revocable living trust and providing that when that parent dies, the trust becomes irrevocable for the benefit of 4 or 5 children, and names 2 children as the co-trustees of that trust after the parent dies. So our trust code says those trustees may act together. However, sometimes parents will say, you know what, I live here in Louisiana. One of my children who I want to be a trustee lives in Florida. Another one lives in California. I want them to both be co-trustees, but because people are all over the place, let's provide that either of them may act independently. They get along great. There's not going to be any conflict. Let's provide that either one of them can act as a trustee instead of both of them having to act together. So we see that sometimes. Now, moving on, when there are 3 or more co-trustees, sometimes parents say, I'm leaving assets to a trust for my 3 children. I want all 3 of my children to be the co-trustees. So when there's 3 or more co-trustees, the powers of a trustee may be exercised by a majority of the trustees. And again, some settlors deviate from that. Sometimes they'll say, I'm going to name 3 co-trustees, but if they have to take some action, I want all of them taking that action together, all 3 of them, not just a majority. So sometimes people like to deviate from that specific trustee power provision in our trust law. And then occasionally we see people wanting to, which is allowable under our trust law. Sometimes a settlor of a trust will have more than one trustees, but they want to confer different powers upon different trustees. So for example, somebody may set up a trust and they say, I want this trustee handling all of the investment decisions relating to, securities and other investments. And I want this trustee handling everything related to the real estate, the farm, the immovable property, whatever you want to call it. So it is permissible for a settlor of a trust to confer different powers on different trustees. Okay, so I think the bottom line here is a lot of people just don't realize that there are specific rules related to the powers of a trustee. I think many people think that there aren't rules. And so, a trustee can kind of do whatever they want to do, but that ain't the case. There are specific rules. And what makes it a little bit challenging is often neither the beneficiaries nor the trustee can determine what the trustee's powers are by merely looking at the four corners of the trust instrument. So when they can't determine a trustee's powers by looking at the four corners of the trust instrument, or however many pages it is, then they have to look to applicable trust law to determine whether a trustee does or doesn't have a certain power. So there you go. This, if I could just get everybody who's involved in a trust to watch this video, it sure would eliminate a lot of questions, or would have eliminated a lot of questions over the years. To eliminate more questions, you want to make sure you obliterate the like button. That way you'll be telling YouTube, hey YouTube, when I pull up your site, why don't you suggest maybe a few more of Paul's videos so I can get more informed about my estate. And then if you haven't already done it, hit the subscribe button and the notification bell. That way you don't miss anything as I keep over the coming days, months, and even years creating more practical, useful estate planning content so that you can know exactly what you need to do to protect yourself and your loved ones. Okay, I'm Paul Rabalais. You have a great day. Take care.